Hi, this is Bradley Hennings, a partner with Chisholm Chisholm Kilpatrick, and we're here today to talk a little bit about a day in the life of a BVA board member or veterans law judge, which is a position that I previously held a number of years ago. So let's talk a little bit about a day in the life. This lecture, which I often offer at law schools and other legal presentation venues, covers who are the Board of Veterans Appeals veterans law judges and how are they selected, the criteria and selection process, what the VLJ core actually looks like, what the day-to-day of a VLJ is, as in what are they doing all day, and some advocacy tips before the Board of Veterans Appeals. Thoughts about what the two topics above mean for client advocacy. So before we get started, this will be a description of what has generally happened, as well as my specific experiences. BVA decisions themselves are non-precedential, meaning that you can't necessarily rely on one BVA decision to decide your case, and that the veterans law judges have autonomy in interpreting the law and case disposition. So the Board of Veterans Appeals' mission is to conduct hearings and dispose of appeals properly before the board in a timely manner. And its jurisdiction are all questions in a manner which is subject to decision by the Secretary, shall be subject to one review on appeal to the Secretary. Final decisions or such appeals shall be made by the board. What that means is the board gets to be the final decision maker on behalf of the Secretary of Veterans Affairs on benefits issues before the Department of Veterans Affairs, the administrative level. So outside of, you've got within VA, you have local VA offices, also known as the VA regional offices. You then appeal those determinations, if you don't like them, to the Board of Veterans Appeals. And if you don't like the decision at the Board of Veterans Appeals, you can go outside of the department and you start to go to the U.S. court system, the U.S. Court of Appeals for Veterans Claims, which is located in Washington, D.C. If you don't like their decision, you can appeal to the U.S. Court of Appeals for the Federal Circuit, which is also based in D.C. And then finally, although this is rare, in a handful of cases, you can go to the U.S. Supreme Court, which historically has not decided very many veterans law cases, although they've decided an increasing number in the last, I would say, 10 to 15 years. So where does the board fit within the Department of Veterans Affairs? Well, you have the Secretary, Deputy Secretary, and Chief of Staff in the Office of the Secretary. And typically you have the main administrations of the VA. That is the Veterans Health Administration, which is the largest integrated healthcare system in the United States. And they have hundreds and hundreds of thousands of employees. You have the Veterans Benefits Administration, which is who we typically deal with, who decide benefits claims at the regional office level. And then you have the National Cemetery Administration, which administers the VA cemeteries. To be clear, they do not administer Arlington National Cemetery. That is controlled by the Department of Defense. It is not a VA cemetery. But on the side, you have the Board of Veterans Appeals, who is separate from the three administrations and reports directly into the Secretary of Veterans Affairs. Now, the organization of the board, we have a slide that is being put up. That is not currently accurate. That is the most recent slide that the Board of Veterans Appeals had put on its website. As you can see, there are some missing boxes there. Currently, the acting chairman and vice chairman is Kenneth Arnold, and he is running the day-to-day of the Board of Veterans Appeals. He's supported by a number of deputy vice chairmen, some of whom are in acting roles, and these are all senior executive service folks that are helping support the board's mission of issuing decisions and hearings. So who are the board's veterans law judges and how are they selected? So the Board of Veterans Appeals is composed of men and women who possess well-honed veterans law skills and share a broad perspective of government and public service. They review benefit claims determinations made by VA offices and issue decisions on appeals. Now, what this means is historically, anybody who became a veterans law judge was very experienced in veterans law. They were often staff attorneys at the Board of Veterans Appeals, attorneys from VA's Office of General Counsel, and occasionally attorneys who had worked at the Court of Appeals for Veterans Claims. A few years ago, a decision was made to widen the net to choose veterans law judges. And so they took many folks without veterans law specific experience, but many veterans themselves and folks who had worked in other administrative systems, but who did not have veterans law experience. So typically the applicants must have 7 years of experience as a licensed attorney preparing for, participating in, or reviewing formal hearings or trials involving litigation or administrative law. In reality, most of VLJs historically have had somewhere between 10 and 20 years of legal experience at least before they were appointed to the role. You've got to be able to analyze claims files. You've got to be able to draft appellate decisions. You've got to be able to conduct hearings and manage a group of staff attorneys who are drafting these decisions. These staff attorneys are equivalent to law clerks in court systems. So there were all sorts of evaluations. This was an example of the evaluation that I underwent when I became a veterans law judge, with many steps where you had initial screening, you had specialized screening, and the screening was a very detailed federal resume involving many pages of information, essay answers to questions, et cetera. It was quite a long application. You eventually get a VA Executive Resources Board rating and ranking, and then you undergo a series of interviews, a group interview by the Board of Veterans Appeals initially to determine final nominees, and then you have a nomination by the board acting chairman, executive in charge, or chairman, depending on who's in charge, and you get interviewed by them. I was interviewed by the executive in charge at the time, and then I was again interviewed by the chief of staff of VA at the time. And then I interviewed with someone from the White House Personnel Office. Once you've gone through all that and everyone has said yes, you actually are appointed by the President of the United States. You don't get to meet the President, but they sign off, they check a box, they sign something, and you are appointed, you are approved of and appointed by the Secretary of Veterans Affairs to become a veterans law judge, or statutory term is board member. So here's an example of the board members in 1933. Obviously, it was a much smaller group. Back then, it was both doctors and lawyers. And it was all men initially. This was particularly the case when in 1945, General Bradley, who was then Administrator of Veterans Affairs, said, the board should be filled by appointment of veterans with wartime service because of the character of the work and the constituency served. And so this really morphed into the board hired veterans, and not just veterans, combat veterans in particular. And because of that, no women were appointed to the board. However, in 1977, this policy was found to violate Title VII. And so today, veterans are a mix of veterans and non-veterans, combat veterans, non-combat veterans. You have a very diverse group of individuals who are doing this, who have military experience and who don't have military experience. So one of the biggest jobs of the veterans law judge is managing, mentoring, training, developing, and leading staff counsel. And this was one of the areas I enjoyed the most, because you're helping staff counsel dig through the files and come up with the decisions. So you're analyzing the evidence, you're appraising the previous adjudicative processes by the Veterans Benefits Administration, you're correlating and resolving evidence, you're considering that evidence, and then you're issuing decisions, which are completely independent, meaning VA, and no one at VA is telling you how to decide an individual case. It's what they call decisional independence. I know a lot of folks may not believe that, but no one ever told me, you have to deny this, you have to grant this. Now you have to work with the facts and you have to work with the law. And as long as you're working within the facts and the law, you can decide whether to grant, deny, remand, or dismiss a case without interference by anyone within the Department of Veterans Affairs. So you're also able to and have to rule on motions as a veterans law judge, and you conduct in-person or video conference hearings. These days, post-pandemic, these hearings are typically done at either the veterans law judge's home or office, along with the veteran or their dependent's home or office. So you don't have the same kind of hearings at the regional offices typically anymore. There are still hearings offered at VA's central office, the home of the Board of Veterans Appeals, which is currently at 425 I Street Northwest in Washington, D.C. You need to determine whether there are other parties with adverse interests who may be joined in a contested appeal, because there are some appeals where it's not just the veteran appealing, but it could impact their dependents or other people currently receiving benefits. And you can recommend to the chairman that subpoenas be issued or revoked. I will say that I've never actually seen a subpoena issued or revoked in the wild. It is very hard to actually get one of those enforced, and so they're typically not issued. There's other ways to get the evidence that's required. All right, so what? So how does this all affect client advocacy? That's really the question. How are you able to help your veteran clients or help yourself? And so it's the golden rule of advocacy. You want to make it easy to say yes. You want to make it easy for the veterans law judge to say yes. So in a lot of ways, you want to begin with the end. You want to say the record's complete. We don't need any more evidentiary development. The evidence approximates balance on whatever element of the claim hasn't been met up until now, maybe, and the claim must be granted. So you're beginning with the end. You want to focus on the reasons that it was previously denied, because that's usually where the weakness of the case is, or where the regional office saw the weakness of the case. Now, the Board of Veterans Appeals does what they call a de novo review, meaning that they don't take anything that's happened previously into account except for positive findings in the AMA, in which case they're bound by those. But otherwise, they don't care that the regional office didn't do it right or that they denied it. They're going to take a fresh look at the case itself. So you're going to focus on that reason for the denial. For if it's a service connection case, you're going to focus on the in-service incident, the current diagnosis. Is there a nexus or a connection to your service and what happened in service? For a rating issue, you want to focus on the symptoms, the laboratory findings that are in the record, the effects on your day-to-day life. You really want to focus on the rating code and the criteria for that rating code that you're rated under. And for effective dates, you want to talk about how and why the date should go back further. Lay it out to the adjudicator, in this case, the veterans law judge, like they were 5 years old. Lay it out really simply and saying, hey, VA's gotten this wrong. Here's why, and here's what they did. Here's why it's wrong, and here's why what I'm saying is right. The in-service element, things you can focus on, obviously government records, which VA is supposed to have gotten, but sometimes they can't find them or they can't get them for whatever reason. So you want to focus on government records. You want to talk about the places, types, and circumstances of your individual service. If VA doesn't already have it, you want to get the official history of your unit. You want to get medical records that maybe they haven't been able to get. You want to submit awards, decorations, memorabilia, photos, anything that'll help support it. There's cases where there's missing service records because of the infamous 1973 fire at the National Personnel Record Center in St. Louis. And so in those cases, VA has a heightened duty to assist and explain. VAs must obtain unit history and research histories if you've indicated they're relevant, but sometimes they just can't get them. And in which case, anything you can do to assist them to make a positive decision in your claim is what you want to do. So let's talk about the 3 obstacles to a grant. And those are often the unrecalled fact, when, where, who, why, how, the unsubstantiated allegation, where you've just got a bare statement of what happened, and then the unfocused claimant, witness, clinician, and adjudicator. So talking a little bit about this, the unrecalled fact is you want to be specific, again, about the when, where, who, why, and how. It's easy to get caught up in a story when you really want to nail down the facts as you recall them, right? As much as you can recall. Unsubstantiated allegation. It really helps if you have some kind of documentary support. It's not required because lay evidence is extremely important, but if you've got anything to back that up, it's great. And then the unfocused claimant, witness, clinician, adjudicator. Stay focused on the issue before the veterans law judge. You don't want to go far afield. You want to talk about the issues on appeal and the elements of those issues on appeal, because that's what the judge really wants to hear about. So dealing with the unrecalled and unsubstantiated, you want to go to the attic. Look for in-service letters, certificates of appreciation, photographs, souvenirs, unofficial awards. You want to find the doctor, post-service medical reports, bills, prescriptions, post-service employment medicals, workman's compensation, Social Security disability records. And then you can get current letters from family, friends, service buddy statements, basically anything you can come up with that will help support your contentions and your allegations as to what happened in service and how it's affecting you now and how those two things are linked. And why are all these records valuable, particularly the records made back at the time? It's because they're prepared at the time for the purpose of recording of the event. And so they tend to be assigned significant probative value. It's an evidentiary term. It means that the judge is going to look at that much more favorably when you've got that kind of evidence backing up your story. So anything you can find from the time that you're claiming these things occurred is incredibly valuable. So for rating of service-connected disorders, again, you want to focus on symptoms that meet the scheduler criteria. For extrascheduler consideration of ratings, you want to talk about things like marked interference with employment, frequent periods of hospitalization, and why the rating criteria don't accurately capture how this disability is affecting your day-to-day. So you want to check the rating schedule in 38 CFR Part 4. You want to track the diagnostic code. You want to look for alternative diagnostic codes that maybe you could be rated under that are more applicable to your particular disability. And for total ratings and for TDIU, you want to specifically raise and cite evidence that support it if you can. Social Security records, workman's compensation, unemployment benefits. Have you had vocational rehabilitation? Was it successful? Was it not successful? All of these things help inform the judge's decision. You want to deal with negative evidence. You want to talk about why your claim seemed to be denied by the regional office and how that VLJ should consider it. So, for example, if you have had some kind of negative evidence such that, they said, hey, there's nothing in service showing you had a back injury and you denied ever having a back injury when you were in service, you want to talk about the reasons for why that might be the case. Don't ignore negative evidence. Address it head on with the veterans law judge. Try to counter it. You want to ask for specific dispositions. So if you want a higher rating, don't just say, please give me a higher rating. Say, give me a minimum of 40% rating, for example, or a minimum 20% rating, not just a higher rating, and then explain why you're entitled to that. You want to argue for the grant and tell the board how and why they should do it to the extent you can. So for medical opinion evidence, you want it to be qualified, informed, and responsive. So particularly if you're talking to your own doctors or you're going out and getting private medical evidence, obviously VA will have its own compensation and pension examinations that they get typically from contractors that they've hired, and they have their own questions that they're going to ask you. But medical opinions generally, you want to make sure, is that person medically qualified? Is there a physician specialty required? Was there adequate testing done? Was this a cumulative or corroborative opinion? Was there an opportunity to observe the veteran in person? Was that necessary for this disability? Was it factually informed? Did it address the veteran's history, the pre-service, service, and post-service medical and relevant non-medical history? Is there an occupational history considered? Was there substance abuse considered? And is it responsive to the questions you're asking the clinician? The strength of the opinion and the why. Was, could be, maybe, could not be ruled out, could possibly be related. What you want is a connection, a rationale. You can't just say, because I'm a doctor, because I'm a clinician. You want something that says the development of this disorder is consistent with what the veteran describes. The current state of medical science supports this contention. You want a why. You want someone to link, here's why it's related to service, and then some sentences with support that explains that and explains it in some level of detail. It doesn't have to be pages long, but you really need a couple of sentences to connect A to B. Hearings. Let's talk a little bit about hearings. So in hearings, you're going to go appear before a veterans law judge, typically online, and there'll be a pre-hearing conference, which is designed really to clarify the issues, You develop stipulation. Sometimes you'll establish the length of the argument that will be permitted. You agree to what's going to be covered, and you're going to take any other steps that will make the hearing itself be more efficient and productive. Typically, you're going to have a representative with you, be a representative, the veteran, and the veterans law judge. So often you'll have three different folks on three different screens engaged in this hearing, and so there's a conference to decide how it's going to go. Most hearings will last anywhere from 20 minutes to an hour. I've seen some hearings last up to 2 hours. I've seen some hearings be as short as 5 minutes. It all depends on the number of issues, what's going on, what everybody has to say, etc. The purpose of the hearing is for the board to receive argument and testimony relevant and material to the appellate issue or issues. And so the hearing will not normally be scheduled solely for the purpose of receiving argument by a representative. Such argument may be submitted in the form of a written brief. In the legacy system, the VLJ holding the hearing was to be the person deciding the case. But in the AMA, the VLJ holding the hearing is not necessarily the one to decide the case. So for hearings, really strongly recommend that you not just hold a hearing to submit argument. You can submit that with a brief. They will read it. There's no reason that during the hearing they're going to listen to it any more than as if you submit a brief. In fact, none of the VLJs really remember their hearings. They'll take some notes, but it'll be made into a transcript, and then they're going to read the hearing. So if they're not going to read the brief, they're probably not going to read the hearing transcript either. So I strongly suggest if you're just going to submit argument, submit it via a brief, then you won't have to wait for the hearing, which can significantly delay cases. But if you are having a hearing, you really want to focus on testimony. You want to focus on the veteran, and you want to focus on their experiences and the testimony that provides evidence that goes to what the issue is on appeal. So these are non-adversarial hearings. Parties to the hearing are permitted to ask questions, including follow-up, but cross-examination will not be permitted. VLJs may set reasonable timelines for the argument, and they may exclude certain things that they really think are not relevant. And that's because there are a lot of hearings these VLJs are scheduled for on any given day. And while they want to give you your time to explain your issues, they don't have unlimited time. If they spent 3 hours with everyone, they wouldn't be able to get through everyone. And frankly, if you have a focused presentation, you shouldn't need 3 hours to really explain what's going on, to focus on the elements of service connection, to focus on the rating issues, to focus on the effective date arguments. So you really want to stay focused during your hearings. So a veterans law judge has a duty to fully explain the issues on appeal and a duty to suggest that a claimant submit evidence on an issue material to substantiating the claim. Practical things. Turn off your cell phones. Make sure your microphone's working. Try not to rustle papers. You want to brief clients. You want to understand what's happening, who's who in a hearing, and what's going on. For rating cases, include lay witnesses, spouses, child, friends, coworkers, who can talk about the effect this disability is having on your day-to-day functioning. They can describe the functional impairments to your life. This is so important. You want to use leading questions. If you're a representative, use leading questions. The best hearings I've ever seen are when you use a leading question and the veteran simply is answering yes or no. For openings and closings, you want to focus the VLJ on the disputed element. You want to lay out for them how they can grant the claim. So here are some realities for a VLJ for a hearing. Even if the VLJ is the same, the one that's holding the hearing and making your decision, they're unlikely to remember the hearing itself and will review the transcript as they would a brief. VLJs are doing hundreds and hundreds of hearings, and they may not see your case for months or years after they held that hearing. So they're really going to refer to their notes and the transcript. VLJs are scheduled for between 6 to 12 hearings a day. For this reason, they may try to move things along or appear disinterested. They're people. By the end of their hearing day, it's been a long day. It's not an excuse. It's just a fact that you may not be getting the freshest adjudicator there. Advantages for a hearing. VLJ may ask questions directly. It's a personalization of the case, particularly if there's credibility issues, if lay testimony is absolutely crucial. often for military sexual trauma cases, for sympathetic widows. Hearings can be very helpful, but there are lots of disadvantages in holding hearings too. You have delays in scheduling and transcription, sometimes delays of years. You have unpredictability, meaning you don't know what a veteran is going to say. You don't always know what a witness is going to say. It may be unhelpful to the case. You have potential travel and cost for travel for your client. The hearing testimony may be redundant to what written evidence is in the record, or it may contradict that written evidence, thereby tanking the case. It really could hurt your client. Your client may share information that's not necessary or not helpful, and you're typically only allotted up to an hour for the hearing, even though some hearings are longer and many hearings are shorter. Well, thanks again for watching. This is just a little bit of an overview of what a veterans law judge does day to day. I hope you enjoyed it. If you have any questions or comments, please leave them in the comments. Otherwise, check us out at cck-law.com, and don't forget to like or subscribe. Thanks again.